we've now got, people can see we've got some good numbers already logged in. So I think we will make a start. Just briefly, obviously, you know what the subject matter is from the title, and I think we issued some preliminary indication of the scope of matters. Thank you all those who not only registered but also added some comments, because they were very useful in helping us to structure matters, so that some topics that we wouldn't have otherwise included, we have added to the webinar. So if we can just turn, and Ashley's I think going to be in charge of the slides. As a brief synopsis, what we're going to cover, we'll start with, in a sense, that policy position in terms of the NPPF, but also touch on Article 4 directions, which is one of the points I think people raised. Ashley's then going to talk about something very specific in terms of the pitfalls, where you're dealing with material changes of use, but there is some physical development involved. We'll then move on to prior approval matters, a simplistic point first of all, but then the thorny question of how you deal with the principle of development. Then external appearance, which in some senses arises out of that previous discussion. Heritage matters, I know quite a number of you have raised, and it is a challenging topic, so we'll talk about that. We'll look at town centre and commercial freedoms, time limits. Then I think the next one, we've got a few more topics. Fallback position people have raised, and then we'll look at the two cases which I know that many people will have seen, the Rights Community Action case and then the cab housing case. And then if we've got time, we'll pick up on questions. As I think we've said there, because of the numbers of people involved, we can't really have it as an actual live Q&A session. So if you don't mind, we'll do it via the chat function. If you've got a question, put it into the chat box. If we've got time and it's possible to deal with that, we'll try and deal with that. But as I'm sure you know, don't please come up with your nitty gritty. Well, actually, I've got this DC problem on my desk at the moment, and I'd really like some free advice on that, because I'm afraid this kind of forum isn't going to be practically the way to deal with that. So if we then start, and Ashley will start with this, which is the relevance of the NPPF to making decisions where they arise for decision under the GPDO. Oh, sorry, actually, no, there is one more point. Sorry, I should just say that, yeah, this was just almost like a health warning. I've just summarised there the position as to how large the GPDO now is. And the consequence of that is that we're not clearly can be able to deal with 170 classes of development, and we've focused on a number of the more recent changes, and I know again from your comments they are particularly a subject of some concern. And I think, yes, the answer I did see just on the chat, there was a question, will there be a as it were an opportunity to see the presentation electronically? I think yes there will. Whether we put it on the website or whether we email it to participants, I don't think that's yet been decided, but certainly there will be an opportunity to access it. And if I can also say before we start, the last slide is a list of case citations, so we haven't given you in the presentations all of the case details, but they are on the final slide, so you will have access to those references. Okay, so if we now then start, and Ashley will tell us something about the NPPF.
Thank you, Michael. Good morning, everybody. Yes, I'm going to cover the relevance of the framework within the GPDO, and as a number of you will know, that the framework is often required expressly to be considered as part of the prior approval questions that an authority needs to answer if it decides that prior approval is required, and then goes on to decide whether or not to grant it. But it's important to note that the prior approval process, whilst it is invites planning judgments to be struck on the questions that are there set out within the relevant class, The framework is only relevant insofar as it is connected to answering those specific prior approval questions. So, for example, if there's a prior approval requirement to consider contaminated land or flooding, the framework policies may well be relevant and need to be taken into account in answering whether that particular prior approval condition is satisfied. But it would not be appropriate to apply more general elements of the NPPF. And what I mean by that is quite neatly illustrated by the East Herts case. And there's an exception to every rule. So as Michael quite rightly said, we've got a slide setting out all the citations, and we haven't included them to avoid clutter, but to just demonstrate that we give of exceptions. I've then put the citation in this slide. And this case is quite interesting because it was a prior approval request of an authority, and the authority decided that prior approval was required and refused it, and then it went on to appeal. And it concerned Class Q of Part 3, which many of you all know is the agricultural buildings to residential dwellings change of use class. And within Class Q, there is a requirement to seek prior approval of an authority before getting on and implementing the PD tolerance, the change of use. And one of the prior approval questions is whether the location or siting of the development is impractical or otherwise undesirable. And what the local authority argued in this case was that that therefore brought in the bit of the framework that deals with isolated homes in the countryside. And for those of you who grapple with that particular policy, you'll know that the policy is, and has been for a while, that new isolated homes in the countryside should not be permitted, save for exceptional circumstances, and then it sets out a number of examples. And the authority contended that that policy should be taken into account when answering the prior approval question as to whether the location or siting was impracticable or otherwise undesirable. And the judge, Mr. Justice Dove, in that case, gives a careful analysis of the prior approval status versus a conventional planning application. And his conclusion was that it wasn't necessary or required to take that into account because it's not to apply the framework so as to frustrate the whole purpose of the particular permitted development class. So, for example, if one were to apply the new isolated homes in the countryside policy, one would effectively be refusing prior approval for almost every agricultural to residential change of use prior approval application, because by necessity they are often going to be in the countryside and they're often going to be isolated locations applying that policy. And he decided that if you were to bring that in, you would effectively frustrate the whole purpose of the prior approval class. So in summary, yes, the framework is relevant. It is expressly relevant in a number of cases, but only insofar as it is necessary to take into account to answer the specific prior approval questions, and it shouldn't be applied so as to frustrate the overall principle of the particular permitted development class.
Thank you, Ashley. So if we then turn to the question of the NPPF and its relevance, if you're thinking about making Article 4 directions, I don't know whether that's a military plane just flying overhead. It sounds quite loud.
Very loud, yes.
Yes. Obviously, you're all familiar with the basic provision that you can make Article 4 directions as an authority to remove or restrict permitted development rights in parts of your area if you think that is justified to do so. But the NPPF has policy tests which it sets out on when such directions would be justified. And obviously you will be aware that the Secretary of State has the power to cancel or modify an Article 4 direction in most cases, and therefore, were you, as it were, to blithely disregard altogether the advice in the NPPF, two things might happen. One, you might be the recipient of a judicial review challenge to your decision for failing to take into account something that was material. Or secondly, if it was an egregious example, the Secretary of State, if tipped off by an affected person, might take it upon himself to cancel or modify your Article 4 direction. So obviously you do need to be alive to the NPPF guidance. You can't just treat it as simply something that's out there. You ought to be taking it into account if you're thinking about Article 4 directions. And what you will know is, obviously, it's been long-standing policy on the part of the Secretary of State that Article 4 directions should be only used rarely to take away what has nationally been decided to be appropriate. But the current paragraph 53, as it were, ratchets up the test, particularly in relation to attempts to remove Article 4, PD rights to allow non-residential changes to residential changes. And as the guidance there sets out, you have to effectively show that it's necessary to avoid wholly unacceptable adverse impacts. And then it gives examples. This could include the loss of essential core of a primary shopping area, which would seriously undermine vitality and viability, but be very unlikely to extend to the whole of a town centre. So that gives you an example. And then also in other cases, you have to show that it's necessary to avoid wholly unacceptable adverse impacts. So that's quite strong language. And again, it gives an example, demolition of local facilities, i.e. community assets and things like that. And then it also tells you in all cases, what you're doing needs to be based on robust evidence and should be applied to the smallest geographical area possible. So effectively, it's not as it were, a welcoming climate for Article 4 directions. And so unless you think that you have got a justified case, since you have to accept that the Secretary of State has granted the various freedoms through the GPDO, Parliament had the opportunity through legislative scrutiny to interfere with that if it wanted to do so. It hasn't done so. So in a sense, whether they're good things or bad things, they are part of the regulatory landscape that planning authorities need to take into account. Okay, so I think we can then move on from the NPPF, and Ashley's going to tell us about a particular pitfall when you're dealing with changes of use.
Yes, thank you, Michael. So I'm going to deal with the relevance of plans, approved plans, to material change of use PD rights, so specifically thinking about those within Part 3. And as we know that there's a requirement to submit a plan showing the site and the proposed development when seeking a determination as to whether prior approval is required, and if required, whether to be approved. And if it is then approved, the prior approval is approved in accordance with the details approved or provided, and that's set out within that section. But as we know, a material change of use permission, be it an express grant of planning permission or a deemed grant by development order, is for a specified activity, i.e. to change the use of land or buildings from X to Y. It isn't a permission to use the land for an enduring use. And that may seem a very pedantic distinction, but consider this particular example. If prior approval is granted on a set of approved plans to change an office block into residential flats, but at the point that the office block is changed in its use from offices to residential, the building happens to contain an unauthorised extension that was not shown on the approved plans, but then the unauthorised extension is demolished So you are then left with the building in a residential use in accordance with the approved plans. Question for you is whether the use of that building is lawful. And a great many people might have said yes, because effectively what you were left with was a building that was in use in accordance with an approved set of plans. Just there was the technical fact that at the point that change of use occurred, the building was not in accordance with the approved plans because it had its unauthorised extension. So the answer to this question came before an inspector and then on to the High Court, and the answer is no. And the reason for that is because of the interpretation that Mrs. Justice Lang in the High Court placed on Article 3.5 that explains that a prior permitted development right does not apply if, in the case of permission granting connection with an existing building, the building operations involved in the construction of that building are unlawful. And there had been a diversity of opinion, or certainly a diversity of opinion before the inspector in that case, as to whether that applied to permitted development rights that were for changes of use only versus permitted development rights for building operations, extensions to buildings. But the High Court placed a wide, I suppose, interpretation on Article 3.5, or preferred the wider view, which is that if one is dealing with a permitted development right, which is purely for a change of use, and that at the point that change of use occurs, the building to which it relates is not authorised or not wholly authorised, then Article 3.5 bites and means that the change of use is not covered by the permitted development order. And so in this case, RSBS, notwithstanding that the building ended up in its authorised form and use, because at the point that use took place, that change of use took place, it was not authorised, and the permitted development right was disapplied by Article 3.5, the use of the building for residential purposes was not lawful, and the enforcement notice was upheld. But query another case, we change the facts slightly and say that what if there was a variation in the approved plans, but it did not involve any operational development? So, for example, if we're dealing with internal subdivisions of a building, well, potentially one is still in a situation where the prior approval right is not available. If, for example, the degree of variance between the approved prior approval plans and at the point the material change of use took place was sufficient to mean that the material change of use which took place was not an implementation of the prior approval permission, but was otherwise development without permission, well then in those circumstances, potentially also the use of the building for its authorised use would not be lawful. That is, of course, a question of degree. It is a question of fact and degree. The difference between the approved set of plans and what has happened is sufficient to mean that it's not an implementation of the approved permission. That's a question of fact and degree. And it's also a question of fact and degree at which point the change of use actually occurs. And IMPI is a useful case on that for office building and for blocks, especially because it explains that when you're dealing with a conversion of, for example, an office block to residential, it is a progression, a spectrum. There comes a point at which enough of the building has been converted that the use of the building overall has changed into residential from its previous office use. But that is a fact-sensitive judgment. But assuming those judgments went against you, well, then that is a very significant pitfall that could mean that an otherwise approved use is no longer authorised. So definitely something to look out for.
Thank you, Ashley, for that. I think we've jumped a slide, haven't we? Haven't we got a short point?
I thought there was one. Oh yes, there was. Yeah, I double clicked.
Yeah, which I think you were just going to tell us about. It's just puts to bed an old chestnut, as it were.
Yes, and in a nutshell, prior approval does not operate retrospectively, and Winters is authority for that. And Winters was approved or cited without any adverse comments by the Court of Appeal in the Rights Community Action case that I'll discuss in a moment at paragraph 29. So I think we can safely now say that if you've started the development, you cannot then save that by seeking prior approval retrospectively, and an authority would be within its rights to refuse to consider a prior approval application if the relevant development had already started. Thank you. Sorry, Michael.
That's all right. Fine. All right. So we now come on to one of the matters which I know has been sort of the subject of some debate in terms of recent cases, and it's really to what extent, because you've got a permitted development right, but then that is subject to seeking and obtaining prior approval, to what extent the prior approval can be said to allow you to consider matters which relate to the principle of development, and what does it really mean to say, well, you can't consider the principle of development because we've already got a PD right. And you know, the cases weren't, I have to say, making it terribly clear until I think the most recent case, Murrell, which is a Court of Appeal decision. The discussion on this particular issue in Murrell is completely obiter, i.e. not part of the binding part of the decision, but there was considerable discussion of the issue in Murrell. It was an agricultural development case, and the inspector, amongst other things, had refused to give prior approval for an agricultural building on the basis, according to her reasoning, that the Court of Appeal thought involved her attacking effectively the principle of new development in the countryside, having regard to policies to restrain development in the countryside, rather than specifically focusing on, well, what was wrong in terms of external appearance and scale, etc., of the particular building that was proposed in its particular location. And what the Court of Appeal said is, well, the principle is not up for reconsideration via the prior approval process. And although they said that the analogy between outline and reserve matters was not a precise analogy, they still found it to be helpful. I have to say, I would urge a bit of caution about that, because I think it can lead you into tricky waters if you, as it were, think to yourself, well, we're dealing with something, as it were, where the PD right is the equivalent of an outline permission and prior approval is the equivalent of reserve matters. That is really only so at a very high level of abstraction. What you should really be doing is looking at the particular PD right, the particular prior approval requirements of its particular conditions, and focusing on those. We seem to have lost the slides, or at least gone backwards. There we are. I say, I mean, it's an analogy, but I would caution against placing too much weight on that. Smolus, I mean, it comes up, there's a number of points in Smolus, but the short point, which is a useful point, is it provides confirmation of the point that the Court of Appeal had already established in the New World payphones case, but that was specifically in the context of telecommunications prior notification. The issue in Smolas was whether, when somebody submits just prior approval, the local authority can actually say, well, hang on, we don't think you're entitled to the PD right at all, because you don't meet effectively an essential condition. In that case, it was an agricultural an agricultural building, and the question was it reasonably necessary for the purposes of agriculture on the holding? And the local authority took the view that the evidence provided was insufficient to allow them to be satisfied of that. So they said, well, we're not going to give you prior approval because we don't think this is a PD case, you will have to apply for planning permission. So it's helpful that it shows that you can consider whether the PD right applies at all when somebody applies for prior approval, if there is obviously some evidential basis for thinking that there are some facts in their application which tend to the suggestion that it's not PD. Then cab housing, which is the most recent case 2022, and that's the one where Mr. Justice Holgate discusses in some detail a range of the cases and a range of the PD rights where prior approval arises. And it's obviously well worth a read of that. And what he explains is that because having secured prior approval, i.e. actually having whatever you've submitted approved, is a precondition to the ability to exercise the permitted development right. And it doesn't crystallize, the right doesn't crystallize until you've got your prior approval. So he says that the principle of development that is established by the PD right is contingent on securing the prior approval for your particular proposal, rather than simply for anything that falls within the PD right. And so its particular effects have to be satisfactory, and therefore the local authority can consider those particular effects, but not generic effects which amount to an objection to principle. And the example he's dealing with there are PD rights where you can put up to 2 stories on top of existing buildings, whether they're it's a dwelling house or it's a freestanding block of flats, etc. And what he says is, well, look, the PD right is that you can put up to 2 stories. It doesn't mean in every case it will be acceptable to put 2 stories, or it doesn't mean it will be acceptable in every case to put the 2 stories to the outer limits of the existing building. And it may be that there are external appearance reasons why you need to rein back the development. And it may be that only 1 story is acceptable in this location, or a story which only goes to one edge of the building and not to the other edge of the building. So that's the point he's making, and that's a very important point. And it's right to say that there are quite a lot of inspectors' decisions before cab housing which have seemed to simply say, in a sense, well, the government has established the principle of development, our hands are tied. Well, that's not right. And you as local authorities, if you are looking at it from a local authority perspective, would also be wise to recognise that that's not right. So then we come to another aspect which also arises in the cab housing case, which was to look in more detail at what is embraced by the prior approval concept of the external appearance of the building. And a number of the prior approval prior approval conditions refer to external appearance. Sometimes they refer to the external appearance of the building, sometimes they refer to the external appearance of the new building, sometimes they refer to the external appearance of the dwelling house, but all of them in that context are referring to external appearance. And as it were, a heresy, if I can call it that, had arisen in a number of inspectors' decisions, prompted no doubt by appellants' representations, to say, well, what you can consider is the building itself, as it were, if it existed in a vacuum. What you can't consider is the way in which the building impacts on its surroundings or on adjacent buildings, because that's not to do with the external appearance of the building. And I'm sure that those of you who look at these things will know that there are quite a number of appeal decisions on PD rights under both Part 1 Class A and under Part 20 Classes ZA and A, where inspectors have gone down exactly that line. Not all inspectors have done that, but there are quite a large number of those decisions. However, cab housing now tells us that that is, as I say, a heresy. It's not the right approach. there is no justification for limiting the actual words in the GPDO by some qualification. And when you're entitled to consider the external appearance of the building, you're entitled to consider it, as it were, in the real world. Is that external appearance acceptable, having regard to its actual context, which could include neighbouring buildings and relationships with neighbouring buildings? So that's, I think, something which is a helpful clarification by the court. And it also leads us into the next, and so it's thorny topic, which is how heritage duties relate to permitted development rights. And you will know that Section 66 of the Conservation Areas Listed Buildings Act 1990 applies when you are considering whether to grant planning permission. And then it obviously sets out that duty about special regard and so on. But of course, with a PD right, the planning permission has already been granted by the grant through the development order. And so when you're considering prior approval, you're not deciding whether to grant planning permission. You're considering simply whether to give prior approval to the matters that have been submitted. Section 72, which obviously deals with conservation areas, does apply more generally to the discharge of functions under the Planning Acts, but it only applies insofar as you're dealing with land or buildings which are inside a conservation area. So that's, as it were, a limitation on that. You will know that there are various permitted development rights which are expressly excluded on Article 2.3 land, and obviously that includes conservation areas. And there are other permitted development rights which are expressly excluded for listed buildings or for development within the curtilage of listed buildings. So that, in a sense, provides a bit of the context, but we then look at how the PD rights work in that context. And what we see is that there are some PD rights where it's constrained. That's to say, if we look at Class MA, which are the commercial, etc., Class E type uses going to dwelling house uses, what Class MA excludes is if your land is itself a listed building or within its curtilage, it's excluded, but not if the land is within a conservation area, or if a ground floor material change of use is put forward. Prior approval has to consider the impact of the material change of use on the character or sustainability of the conservation area. Now that's quite an interesting concept. Effectively, what they've said is if it's a listed building, you don't have the PD right effectively at all. If you're inside a conservation area, you do have the PD right, but if the change of use that's being put forward is to change the use of the ground floor, let's say of an old retail premises which is vacant to residential, then the local authority has to consider what's the impact of that change of use on the character or sustainability of the conservation area. Now that's not quite, as we know, the Section 72 duty, because that's talked about character and appearance of the conservation area, and quite what is embraced by the sustainability of a conservation area is probably a fairly rich topic, which we could spend a great deal of time on, but I'm afraid we're not going to. So then we talk about heritage duties and setting, and here we have a situation where I say the GPDO is careful to exclude certain PD rights where they apply or would otherwise apply to listed buildings, and some of them are constrained, as I say, where they apply inside conservation areas. But it doesn't say anything in terms of restricting the exercise of PD rights where development will affect the setting of a listed building or affect the setting of a conservation area. And so then there is the question of, well, does that come into play, or is that irrelevant? As I say, section 66 doesn't apply to a prior approval decision because that's not a grant of planning permission, and section 72 doesn't apply if the site in question is not in a conservation area. So then the question is, well, can the local authority consider heritage impacts as part of prior approval? To which the answer is yes, but only if they can properly do so within the confines of the stated matters that apply to that prior approval. For example, if they can properly say that the impact on that setting of the heritage asset is an aspect of why the external appearance of the particular building is unsatisfactory. I have to say, I had a relatively recent case. It's an inspector's decision where the site, which was a Class AA Part 20 case, where the site being a block of flats was outside of a conservation area, but the conservation area was immediately on the boundary. And one of the issues being raised by way of objection was the impact on the conservation area. The inspector very carefully dealt with the issues purely in terms of what was wrong with the external appearance and didn't say anything about the conservation area. So he ducked that, which in a sense made his decision, as it were, bulletproof, as opposed to rowing in the conservation area and potentially opening himself up to a challenge that he's taking into account something beyond the scope of the prior approval. Then, sorry, the next topic, I'm afraid, is also down to me before we get back to Ashley's lighter touch, no doubt. Town centres and commercial freedoms. I mean, obviously that's been raised, I think, in a number of the comments that people sent in before we started. And just by way of context, as we all know, we have in modern Britain now far too much town centre floor space, which is either underused or worse, vacant. And as it were, systemically vacant rather than just due to exigencies of the pandemic and so on. Now, obviously, with a plan-led planning system, which the NPPF tells us that we have, it ought to be the job of plan-led strategies to change matters and to move those town centres forward. But of course, that requires both a bold and a commercially astute local planning authority prepared to shake things up, effectively prepared to say this high street no longer functions as a high street, it's too, as it were, too extended, we need to shrink it, we need to have simply a core, we need to take away any kind of policy protection for various parts of the high street, we need to have a new approach. And obviously there are successful examples of that happening, but it's not happening everywhere. And for too many town centres, there's a clinging on to, as it were, outmoded uses in the hope that somebody will come and bring active uses back, and it doesn't happen. So what the government's done is to seek to bring those changes in, not quite through the back door, but through, as it were, a non-plan-led approach, which is to introduce a wide range of permitted development rights. Obviously, Class MA, all those changes from, as it were, what are now Class E uses, you know, the commercial, the retail, to residential, after a fairly short period, that's a 3-month vacancy, and you can then go to residential. Obviously, Class ZA in Part 20, you can demolish a detached, I've said old Class B1 because obviously with Class E as it now is, you know, we're moving away from that language, and you can turn that into a house or into a block of flats. I think the next slide, I think I've got a couple of, well, yeah, a couple of other PD rights, yeah. Class AA of Part 20, 2 stories on top of the old building, and Class AB, 2 stories on top of a terraced building. So if you think about a typical town centre, it may well contain a number of those types of buildings, and these rights will be available to the occupiers or to the freeholders of those buildings, and they will then maybe bring forward those changes. Again, it's quite interesting the way that the GPDO works. You're not always able to consider, well, what are the consequences for the health of the town centre when you're considering prior approval matters. So that for Class A, for example, sorry, Class MA, impact on vitality and viability is not a prior approval matter, but you can consider impacts on local services due to the loss of nurseries or a health centre. And as I said before, there will be some circumstances where you could consider conservation area impacts, that point about sustainability of the conservation area, if your particular town centre happened to be within a conservation area. For Class ZA, you can consider the impact on businesses if premises go to residential. Likewise, in Class AA, you can consider impacts on trade and business if premises go to residential. So there are things that you can take into account, but it is more circumscribed, obviously, than would apply if you were dealing with the Town and Country Planning Act development plan application and you were looking at your policies for the protection of principal shopping streets. You should note, obviously, that Class ZA is not applicable if you've got a relatively new building, that's, as it were, a post-1989 building, nor if you've got an old building in terms of unlisted buildings in conservation areas. And obviously the section 196D relevant demolition issue. And then classes AA and AB don't apply to effectively pre-war, pre-1948 buildings, or to, again, relatively recent buildings, post-2008 buildings. But there's a whole swathe of what you might call late 20th century town centre buildings, which are available for consideration for those freedoms. As we know from what we were saying at the beginning, your ability to remove those freedoms through Article 4 directions, if you're a local authority, is restricted. And so town centres may be facing, therefore, their composition changing more through unplanned PD changes rather than a plan-led, as it were, strategy to change direction. And that is, well, I think, and you might think, a good reason why, if you're a local authority, you might consider taking the bull by the horns and coming up with a strategy of selective pruning of your retail and commercial floor space, which is vacant or underused, by reallocating it to a mixed and residential use. And that might be a better way to actually get the town centres that you want, rather than, I say, leaving it to the unplanned. Well, it depends what happens through the exercise of PD. Right, that's enough from me for the moment. So now we turn, I think, to Ashley to tell us something about time limits.
Thank you, Michael. So a very short point, really, because there's been legislative intervention that's resolved it, but there was a diversity of opinion in the High Court as to if you had a prior approval requirement or requirement to seek prior approval, and that was one of the parts of the permitted development order where the council had a time limit in which it had to reply, 56 days, for example. Some parts of the PD order don't have a time limit, but some parts do. The question was, if the council did not determine the application within that time, but that the parties themselves, the council and the applicant, had agreed a longer period, whether a refusal or indeed approval outside that period was lawful. And the Warren Farm judgment was that it was not, that the council couldn't refuse prior approval outside the 56-day stipulated period, even though there'd been agreement. Whereas the High Court in Gluck decided that you could. But before the case reached the Court of Appeal in Gluck, there's now been a change in the drafting of Article 7, which makes it crystal clear that the parties can agree an extension in either case, either where there's a 56-day stipulated time limit or no time limit. The parties are able to extend by agreement in writing, and that provided the decision is within that agreed extended period, it will be valid.
Thank you, Ashley. Then fallback position, I'll deal with this briefly. It's only on here because I think a number of people have raised it in their comments. Obviously, as you will know, it's often put forward when an application for planning permission is submitted. Well, we've got various PD rights and you should, as it were, benchmark what we're proposing against those PD rights. Now, if it's being argued directly that it's a fallback position and that the applicant will do that if he doesn't get his planning permission, then you're dealing with it as a straightforward fallback argument, and you look at the realism of what is being proposed. Is it a realistic fallback? And if so, you would take that into account as a material consideration. If it's a fanciful, as it were, fallback, because nobody in their right minds would do what is being suggested by way of PD, then you would be entitled to give that very little weight. The alternative position, and there's a case Brentwood which covers that, the alternative is that it's not being said, well, we've got a fallback position, i.e. that's what we realistically are going to do if you don't give us permission. They're simply arguing by analogy, well, the PD right gives us the ability to do X, and we're really only asking to do X plus Y. So if Parliament thought it was okay to do X, then X plus Y can't be that bad, can it? Well, that's a planning judgment question, and how much weight you give it will be a matter for the decision maker. But obviously you can note that the PD right has been circumscribed, and as it were, there isn't a kind of like an opportunity to say PD right plus, because if the government had thought that PD right plus was appropriate, the PD right would have the plus embedded in it, and if it doesn't, it doesn't. So that's fallback position.
Thank you. And then asking from me on the rights community action litigation, and this concerned the challenge to the widespread amendments to the permitted development order, but also the use classes order. And of course, we know that development within a use class, changes within a use class is not development. So that both of those had significant implications for what could be constructed without permission. And one of the grounds of challenge was that the amendments, so the statutory instruments which amended the GPDO and the UCO, were not the subject of a strategic environmental assessment under the SEA directive, the environmental assessment of plans and programmes regulations. And the Court of Appeal, and indeed agreement with the High Court, said that these instruments, the permitted development order and the use classes order, did not set the framework for future development, which is one of the criterion required for a strategic environment assessment. Those types of documents are documents which set criteria against which decision makers can assess individual projects for consent, whereas both the permitted development order and the use classes order do not do that. The Court of Appeal found that on their proper interpretation, the permitted development order already granted permission by way of a deemed grant, and the use classes order decided what effectively didn't require permission by expanding the use classes definitions. And therefore neither of them fell within the requirement for an SEA, and neither of them were amending an existing plan or programme, so an existing document which did set the framework for future development, like a local plan or local development document of that nature. And so that really leads us to the conclusion that future amendments to the permitted development order or use classes order, even if they are wide-ranging and substantial, are unlikely to require an SEA, and therefore any future challenge on that basis is unlikely to be successful.
Thank you, Ashley. And then I think we then move on to cab housing. Obviously, we've already touched on what it has to say about the issue of prior approval and the principle of development, and the issue of what is embraced by external appearance. It's obviously particularly dealing with those abilities to add new residential floor space to existing buildings. And it also looks quite closely at what falls within the umbrella of impact on amenity, and also what is capable to be considered by way of the adjoining premises. And what it makes it clear is that impact on amenity is not limited to the words overlooking privacy or loss of light. Those are included in the prior approval reference as impact on amenity, including those things. And the courts have said this is one of those cases where the word included means examples of what is included. It's not exhaustive, and it's not a justum generis approach of using that to categorize other things. They are simply examples of what you can take into account, but other things that are impacts on amenity can also be taken into account. Very wisely, Mr. Justice Holgate didn't offer any views on what those other impacts might be, but he's very much of the view that the words mean what they say. Then adjoining premises is slightly odd there, that effectively Mr. Justice Holgate takes the view that adjoining premises is wider than immediately adjoining. He says that partly because elsewhere in the order the words immediately adjoining are used, but he says that adjoining in this context can both embrace adjacent and indeed neighbouring buildings, so you don't have to be, as it were, contiguous on the boundary of the site in order for the effect on the adjoining premises to be relevant to the question of prior approval. So I say cab housing is a useful case because it, engages with a number of controversial topics, which I know practitioners have been wrestling with over the last 18 months, 2 years or so, across a range of these PD rights. And we also know that inspectors have not found it easy, which is why there's been a kind of divergence of views in some of the appeal decisions. And it's therefore very helpful to have Mr. Justice Holgate's view on that. There's certainly no appeal has been indicated in relation to that decision, and it seems to put to bed therefore a number of these issues. So I think we've just got a little bit of time for questions. I know that there were some matters have been raised both on the Q&A function and on the chat function. If I can pick up on 2 points, which if I can ask Ashley about, because I think they relate to his initial comment. One of them, it's a question, and it relates to the fact that para 12 of the NPPF says the starting point for decision making is the development plan, and so should that not mean that you can bring the development plan always into consideration of a prior approval? But then related to that is in the chat box, there was a question about climate change, climate emergency, and sustainability, zero carbon. Can that be brought into account when you're considering prior approval of PD rights? So actually, I don't know if you want to just handle both of those by reference probably to what you've already said, but just contextualize them.
Certainly, very happy to. I think the answer is that you can take into account the framework and indeed the development plan, but only insofar as it is relevant to answering the specific prior approval condition questions. And that really goes, the reason for that is, as you said, Michael, the grant of deemed consent in the class is the grant of permission. So you cannot effectively reassess or go behind that principle when you are deciding a prior approval application. I mean, it may be, of course, that the prior approval application is refused because of consideration of those particular conditions, and that may therefore mean that particular development can't be realised, but it could not be refused on grounds that were outside of the specific conditions properly interpreted. And so, for example, if climate change isn't stipulated as one of the conditions, it would not be appropriate to refuse grant of prior approval, because that would be beyond the scope of the exercise before the decision maker.
Thank you. Then I think there was a question which related to the fact that there has been a legal challenge by, I think, London Borough of Islington to Class MA, and are we aware of any update on that? I'm afraid the answer to that is no, it's not. That's not a piece of litigation I think either Ashley or I is involved in, and I'm afraid therefore I can't or we can't tell you anything more about that. There's also a related, one of the comments that came in before the webinar was asking, well, is there any guidance about what a local authority should consider in deciding whether or not premises have been vacant for 3 months, that being a precondition to the Class MA right being available. And again, I'm not aware that that has been yet the subject of guidance in the planning practice guidance series, and it, you know, in a sense at the moment it's a matter of fact and degree for the decision maker as to what they would regard as evidence of vacancy over that period of time. So I'm afraid that doesn't take us too much further forward. We then got a couple of questions opening up what I would regard as a bit of a rabbit hole, because it's dealing with the conservation of habitat and species regulations and how they apply. And the first part is that when you look at the current regulations, the 2017 regulations, they say that they make a particular reference to permissions granted by a general development order made on or after the 30th of November 2017. And then there was a question, well, what does that date apply to? Well, the answer is that that date applies to the date that the development order was made, and that's what it says. And then you sometimes think to yourself, well, what does that mean about, for example, the GPDO, because that was made in 2015, albeit it's been subsequently amended. And the reason why it's a bit of a rabbit hole, and Ashley and I think have both looked at this at an earlier stage, you have to trawl back through the schedules to the various orders and the Act, and what you actually find is that the previous regulations are effectively retained in force to apply to those earlier development orders, so that there isn't a gap in the regime, but it's just that finding that kind of chapter and verse exercise is a little bit convoluted. I don't know if Ashley, you want to say anything further about that?
No, I'd agree with that. Yes, it does on its face. When you look at the current regs, look as though if it's before those regs came into force or the 2015 order, then it's not subject to appropriate or consideration under the regs. But as you say, the previous set are still in force in relation to those previous grants. So yeah, it's not immediately clear, and it doesn't reference back, which is makes it particularly difficult. But as you rightly say, then effectively all PD grants are covered by, or are capable of being covered by the habitats regime in one form or another.
Yeah, and that effectively relates also to the second, I think, query, which is obviously the nutrient enrichment and how does that impact effectively. If you are going to have an effect on an SAC, then there will need to be an appropriate assessment, and that is something which will restrict both the exercise of PD rights, and it will restrict the grants of planning permission in those cases where there isn't a, as it were, a solution to how you can show nutrient nitrate neutrality in your particular area. I think we're slightly over time, and I think, was there anything else that we can very quickly deal with?
Well, just one question, Michael, to which there is a happily clear answer, which is, can section 73 be used to vary prior approval? And there is a case called Pressland 2016 which says you can. Yeah. So I can answer that very quickly.
Yeah, thank you very much. So thank you, Ashley, and thank you everybody who has joined us. I think we will probably put somewhere on the website details of how you can access the materials. I say whether we'll do it by email or whether we'll just put it up as a document. I think we'll decide on that. And similarly, I think in terms of any recording of this session. Thank you all very much, and thank you for your attendance.
Thank you. Cheerio.